If you hire an attorney, the attorney will try to settle your case out of court without filing a lawsuit, without going through all of the effort and time and expense of a lawsuit. Sometimes that doesn't work. If your attorney files a lawsuit, you'll be asked to testify in a deposition. A good attorney will prepare you to testify in deposition. That means spending 1 or 2 or more hours at your attorney's office. You should go over your medical records, your interrogatory answers, police reports, photographs, witness statements, anything that's relevant to your case. You should review them so that you're familiar with your own case and your own medical records. The reason why it's important to review your medical records is you can bet that the defense attorney has read your medical records and will start interrogating you about something that's in your medical records. And if you say something that's different from what's in your medical records, you don't want to be caught by surprise. Your records are not always accurate, and if you want to correct them, that's fine, but you should know that they are inaccurate before you testify. In any case, you always have to say the truth. If there's something that's personally embarrassing that you don't want to talk about, clear that with your attorney first, but always tell the truth, always tell the whole truth, and never lie. If you do, sooner or later it always comes back to bite you, and ultimately the system that we have rests upon integrity. It rests upon honesty. And if you're not honest, if you don't have integrity, then you can't expect the system to work for you. When you're asked questions in deposition, the rule of thumb is take a deep breath, think about how you want to answer it. Don't let the attorney who's asking you questions rush you into answering. Give the question a fair answer. Answer to the best of your ability. Don't over-answer the question. So the old phrase, if they ask you what time it is, don't tell them how to build a watch. But don't under-answer it either by just giving single-word answers unless the question calls for it. Sometimes you'll be asked to make estimates of time, space, distance, how frequently something happened in the past. If you don't know, then the best answer is you don't know. Just because they ask the question doesn't mean that you should know the answer. If you're able to give an estimate, it's good to qualify your answer by saying, well, to the best of my memory, or my best estimate would be, or something like that. But you should never guess, and you should never speculate just to please an attorney who's asking you questions. Don't guess, don't speculate. If you can give a good faith estimate, you can do that, but make sure that you're grounded in your own facts, in your own memory. Sometimes depositions can go for several hours. Take breaks as needed. If you want to talk to your attorney, you can always look at your attorney and take a break, but you should never feel rushed. You should never feel hurried. You should always feel like you are in control. The most important part of your deposition, in my opinion, is the part where you are asked the question. The question is some version of this. Please tell me about your injuries. Or please make a list for me of all the injuries that you had. Take your time when you're answering this question. A good way to think about this is starting from the top of your head and going to the tips of your toes, and give a list of every single part of your body that you remember being injured. It can be headaches, it can be neck pain, back pain, upper shoulders, lower back, hips, whatever it is. Go through every part of your body that's been injured. Even if some of those injuries have resolved in the past, you should still talk about those. Be willing to quantify your pain. Be willing to say how frequently it happens, how bad it is when it does happen. Don't exaggerate, but make sure that you fully talk about your pain so the person who's listening understands what you are going through. Be rich in detail. Here's an example. If you're hearing about a radio ad for pizza, and you hear 2 radio ads, which one is the one that's going to be most most likely to drive you to buy the pizza? Here's one. Come to Ralph's Pizza. We've got good pizza, we've got the best prices, and we have free parking. The other one might be, come to Anthony's Pizza. We've got the best mozzarella. We've got the anchovies. We've got fresh tomatoes, onions, garlic, 4 different kinds of pepperoni, sausage, and mushrooms. We've got it all. When you listen to the ad for Anthony's Pizza, you start paying attention and you start getting hungry. That's because of the vivid detail that is presented in that second radio ad. You want to do the same thing when you're testifying about your injuries in deposition. Give vivid descriptions of the neck pain or the headaches and how they affect you. If it's migraines, talk about how you have to lie down at night and put a towel over your head. If it's neck pain, talk about how you have to massage it or ask your family members to give you a massage. Be rich in detail so that the other side understands what it is you're going through. Remember, a deposition is your opportunity to shine. It's your opportunity to tell the truth. And it's your opportunity to tell the other side what they did to you. So enjoy it.